All right, folks, buckle up. This one's messy. We've got meth charges, resisting arrest, and a defendant who claims the cops themselves are under investigation. This courtroom's about to turn into a blame game showdown.
And we are here for a preliminary examination on a possession of methamphetamine case and a resist and obstruct case.
It's almost completely accurate. The part about an open investigation against Deputy Roloff and Deputy King for the initial stop is actually underway. I've dealt with state troopers in regarding to this matter, and I think that moving forward, I don't see how it could be anything that Deputy Roloff or Deputy King says until the end of that investigation. I don't think how it.
Now, this is fascinating. The defendant's openly betting on an investigation against law enforcement to prove his innocence. That's risky. Judges typically focus on evidence in the case, not ongoing probes. It's like trying to pause the game mid-play and claim victory.
Would be pertinent to what we have going on, and I would be more than willing to sit this dead time and deal with all the time that may occur up until now, until the resolution of that investigation is done, because there's going to be wrongdoing found, I believe.
So, Mr.
In regards to this,
what is the nature? And I don't want you to get into the facts of it. But what is the nature of your complaint to Michigan State Police?
It's not the Michigan State Police. It's Deputy Roloff and Deputy King of Grand Traverse County.
But you said that the state police were investigating it. So what was the nature of the complaint?
There was wrongdoing by Deputy Roloff and Deputy King.
Are you alleging
in regards to the drug, in regards to the possession? I'll say that.
Are you alleging that they're untruthful in some way?
Absolutely.
Mr. Niegos, do you want to follow up or supplement anything?
Absolutely not.
All right, Ms. Carey, any argument?
Can we have Ms. Chandler subpoenaed to court, please?
I'm a little bit perplexed. We've been here 4 times, and I know some of that has been on our part. I have the Grand Traverse County deputies here and ready. It is now almost 5 to 5 or 10 to 5. If the defendant wants to prolong this pending an investigation by the state police, that's up to him, I guess, and to the court. But just so he knows, it could be more than a week, and I don't want to have them come back for the 5th time next week. So if we're going to have it investigated, let's not schedule it until we're certain that investigation is over, then that's fine. Otherwise, we're prepared to move forward.
Well, it sounds like what Mr. Du Bois is asserting is some sort of Brady violation.
Quick explainer. When the judge mentions a Brady violation, that's huge. It means the defense believes the prosecution is hiding evidence that could help the defendant. But here's the catch. That argument usually belongs at trial, not during this early stage.
And I will admit it's been a while since I looked into Brady, but as I recall, during other Brady issues I had, it's not necessarily appropriate to raise a Brady issue at the preliminary examination. It would be more appropriate for a trial, and that issue would be raised by trial. Presumably, if we were to move forward for preliminary examination, any investigation by MSP would be done by then. But even if there is some sort of investigation, that doesn't necessarily rise to the level that there be some sort of violation of either Brady or Giglio. So the court is prepared to deny that request today. But as Ms. Carey indicated, we are already at 5 minutes to 5, and I don't see how we can do a prelim today. But are you guys able?
I am.
The court and staff are willing
to,
if the party, Mr. Du Bois, it's my turn now.
Yes, sir.
If the parties are willing to hang over, we can at least get started on this and see where we wind up.
Your Honor, may I speak?
Whoa! The judge just hit him with the "you talk too much" line. You can feel the frustration boiling over. Question for you guys. Do you think this defendant's being silenced, or is he digging his own legal grave by over-talking?
Mr. Du Bois, you have done more talking than any other defendant I have let talk in the last 3 months. Every time we come in, you complain that it wasn't moving fast enough, and now today has been nothing but stall tactics in order to get it stopped. You've had 3 months to file a complaint with Michigan State Police. They've had 3 months to investigate it. We're here for a preliminary examination today. I have to get this case moving. You can shake your head all you want. You can shake it all you want. But, you didn't have a prelim last week because of your own actions, and now you're asking for another an adjournment today.
That I did. That it was my fault. My child rights are being violated and you're just letting it happen. That's why Ransom was going to throw it out the first time. What do you, I'm not being heard. You are, that's why I'm saying you're biased. You have tried me before in 23, 22. You come from the prosecutor's office. You and Joanna Carey are openly friends. How am I getting an unbiased fair chance here? Furthermore, I tried to fire this attorney already. I want to represent myself. Who knows my case better than I? Me. At this point, I would like to dismiss Mr. Niegos under the, I would like witnesses called at a prelim hearing. I believe I'm entitled to those, Your Honor. I believe I'm entitled to call my own witnesses. I believe I'm entitled to ask questions again, for the officers. None of this stuff, I feel like I'm just being pushed through, and I've been through this enough, Your Honor, that I know I got all the paperwork here that says what I'm entitled to. And yeah, I do talk a lot. You know why? Because I know what my rights are, and every time I don't, I get pushed through this system and I get screwed around. I do. And the investigation has started since day one. Since I come into this jail, I asked to speak with a state trooper. You can call them, get in touch with them. I encourage it because there's wrongdoing here.
Mr. Niegos.
I'm sorry, it's frustrating you. Imagine how I feel.
You're not frustrating me, Mr. I'm here all day, Mr. Niegos.
Your Honor, obviously, I'm yammering and stammering. I'm not entirely sure what to say. He's representing. He knows his rights. He's representing. He tried to fire us before. I did have an opportunity to speak with him. I probably should have put this on the record as to the whole MFR thing in the note from last week. He indicated he was not referring to me or my firm. As such, I was going to continue with him based on his representations here today. I am absolutely more than fine to step aside. And since he indicates again that he knows his rights and etc., then if the court's inclined to discharge me, take zero offense or issue with that.
Has the attorney-client relationship broken down, do you believe?
I know that there's been a previous significant issue between he and a colleague of mine in my firm. The relationship between Mr. Du Bois and myself has not been a upward linear one, so to speak. And based on his representations here today, indicating that he's repeatedly, in his words, tried to fire me, as if indicating somehow I've insisted or I have some sort of vested interest to remain on this case as his counsel. I believe so, Judge.
What about the interview between us that was scheduled yesterday? You've missed two.
Okay, Mr. Du Bois, this is Mr. Du Bois. This is the perfect example. He's saying that the communication process is broken down. He wants out, and yet you want to argue with him. Why, I don't know, but you want to argue with him about it.
Because I want it on record. Why? I'm not just being disruptive. I'm stating what's going on. I should have an attorney that can come in here and sit down with me and go through my case, not 10 minutes before we come before you. This is the problem here. This is how it goes for every inmate that comes in here. If they're not paying for an attorney, they come in here, they the lawyer sees them for 5 minutes. They don't go. How much time have you spent on my case? Tell me some specifics in it, Your Honor. Nobody can. That's why I'm raising such a fit about this. It's unconstitutional. You tell me that I'm getting a good defense by one of these lawyers that spend no time. He's on polycam. We have not sat down one time and went over any part of my case. Not one. You tell me how that's constitutionally right and fair to my fair and speedy trial. Am I right to be represented by a decent attorney? I don't understand why you guys can't see what I see and what other people see. I don't get it. I'm not trying to waste time. I'm not trying to be disruptive. And you know what? I take full accountability for my actions, why I'm in these chains, and
no,
why
I wouldn't say that.
I
I wouldn't be saying anything about accountability or why you're in those chains before you fire me formally. Don't say that.
I want an attorney that will come here, sit down
All
with
right,
me
Mr. Du Bois, let
let
me ask you a question. Mr. Du
This is where it gets real. The defendant feels trapped, stuck with lawyers he doesn't trust, in a system that seems deaf to his voice. But the judge's hands are tied by state law. This tension, it's the heart of every courtroom drama. That's not fiction.
Bois, let me ask you a question.
Yes, sir.
Do you want an attorney or do you want to represent yourself? Because you've said two different things now.
I want an attorney that will come here and that will go over my case and give me the time and respect that I get.
I have no control, Mr. Du Bois. I have no control over who the public defenders appoint. I have no control over how they conduct their interviews. I have no control over that. All that has been removed from the court back during the reforms that started the Indigent Defense Commission. I have no control over that. All I can do is, it sounds like, based on what Mr. Niegos has told me and what you've told me, all I can do is order that Mr. Niegos is removed from the case because there's been a breakdown of the attorney-client privilege. You might get Perry Mason next time, or you might get Barney Fife. I can't say who you're going to get next time. But I do not have an endless supply of attorneys. Do you understand that?
I do understand that. And I don't, am I not entitled to a good defense? Am I not? 5 minutes before we come before you, Mr. Wiggins. Go ahead, sir. I don't want to interrupt.
Thank you. You're doing a very interesting job of not showing that. As I said, I have no control over who is going to be appointed to you. And yes, you do have the right to counsel, but you also have the right to hire your own counsel if you are not happy with the counsel you're receiving. And where you're indigent, which is what you are, I can't just go start knocking on doors and saying, please represent this person. There are attorneys that are under contract and under hire with the Wexford Missaukee Public Defender's Office. I have no control over that. So I'm willing to release Mr. Niegos. It sounds like he's in favor of that. It sounds like you're in favor of that. But I have no control over who you're going to get next.
But
I want to make sure you're clear.
Have control over how they conduct what had 5 minutes to go over. We haven't went over anything in my case. Nothing. Don't you have? Can you point me in the direction of who to complain to? It's not my fault. I'm indigent.
I completely agree.
Who can I complain to so I can get proper and adequate representation?
Mr. Du Bois, if you would give me 5 seconds, can you do that for me?
Absolutely.
You can contact the public defender's office here. They can direct you in a way to make a complaint. As I said, this is not the old days where the court had control over the public defenders. I don't do that. I have no control over who gets appointed, the directions they take a case. That has been entirely removed from the court. That's between you, the state of Michigan, and the Public Defender Indigent Defense Commission. But based on what I'm hearing today, I will remove Mr. Niegos from this case. We will make another referral to the Public Defender's Office for the appointment of an attorney. We'll get everybody back here, but I'm not going to set it for next week. I'm going to put this off until It's going to be, and I'm not going to reset it for a probable cause conference. This case has gone on long enough. It's going to go right back to the preliminary examination. So because of that, I'm going to set it out a little bit longer. We'll go out at least 2 weeks. In the what?
28th of October.
The 28th of October. If the parties can agree and the court finds there's reasonable grounds to put this back on for a preliminary or a probable cause conference, I'll consider it. But it's going to go on the docket as a preliminary examination. Nor can I even guarantee that by the 28th, you'll have an attorney. I had another case today that's been almost 2 weeks, if I recall correctly, that they're still waiting for an attorney to take the case. So just so
at
you're
this
aware
time,
of all
can I
that.
represent myself until then?
I have to be convinced, hold on, before we go any further, everybody in the audience, I'm sorry, we're now over our time. We're going to have to adjourn the prelims for this afternoon, and we'll get them rescheduled for another date. They're going to be rescheduled for 2 o'clock on Monday,
The 20th.
the 20th.
If you go to the front and
You can go out to the front windows where you checked in and get your next court dates. Again, I apologize, everybody. It just ran longer today than what we'd anticipated. So Mr. Du Bois, back to you. I need to be convinced that you are able to represent yourself. Yes, you have a constitutional right to represent yourself, but that's not an all-encompassing right. The court has to be, and you can let the jail go as well. The court has to be convinced that that is a knowing and voluntary waiver of your right to an attorney, and that you have the wherewithal to represent yourself. So before I go ahead and do that, we have a process we're going to have to go through, but I want to be very clear. Are you asking to represent yourself, or are you asking to have court counsel appointed or indigent defense counsel appointed?
I'm asking to be able to have the resources to represent myself and look into my case law, and reference those things until an attorney is appointed so I can better represent myself.
Well, but see, therein lies the problem, because you can't represent yourself in between time of an attorney being appointed. If you've requested the appointment of an attorney, the attorneys can't talk to you, and I can't talk to you in very limited circumstances until you have an attorney appointed. So that's why this question is very clear. Are you requesting the appointment of an attorney, or are you wanting to represent yourself? You can't have it both ways, just so you're clear on that.
So I can't be granted access to a good legal law library so I can actively participate in my case until I have.
You can
a
do
public
your own.
defender?
You can have access to the law materials, but because you've requested a court-appointed attorney, you can't make any filings with the court, and you can't have any communication with the court or the prosecutor's office, except in very limited circumstances.
Okay. Yeah,
Does that
I
make
would like
sense?
to try to get an attorney a public defender that I can work with and that will come here, and to save time for you in the court. All I'm asking for is an attorney to come in, review my case with me, take an interest in my case, so I feel like I'm adequately represented, because at this point, I don't feel like I have been. You can't adequately represent somebody 5 minutes before they go into court, Mr. Wiggins. That's been my whole thing. That's been my whole case. That's why I'm frustrated. That's why I'm an animated person by nature. Anybody will tell you that. The people at the jail, anybody that knows me, I'm animated by nature. I don't mean disrespect by it. And yes, I do get on a rant sometimes, and I am long-winded, but that's because I suffer from disabilities. That's just what it is. And I'm sorry that you feel like I've wasted your time, but this is important. This is my life.
You're not wasting my time. As I said, I'm here all day, 5 days a week. But now Mr. Niegos, I've released you. So if you want to go, you're more than welcome to do that.
Normally, Judge, and I do apologize to your staff, normally, especially since the time. Normally, I don't respond to these kind of comments, because he's not the first nor the last that says these things. But in this case, given the documentation we have in our file and the comments he made, I just would like to put on the record that we've attempted multiple, albeit remote, jail visits. The first one was conducted with my legal and with my research and writing specialist, who
You
does
guys were
all
here.
of our
When they didn't show up, when they didn't show up, it's documented
Mr.
that
Du
you
Bois,
guys didn't even
Mr.
show
Du
up.
Bois, Mr. Du
Yes, sir.
Bois, you had your time. Now it's Mr. Niego's time. You made all kinds of accusations against him. Now it's his turn to defend himself.
Yes, sir.
So the first attempt for a virtual visit, which is always the initial visit that we handle to go over the police reports and the initial things, happened on October 13. The notes in the file. This was also a case that I accepted on short notice. It actually occurred on October 2nd. I apologize. And the notes in the file indicate that essentially the visit was conducted and was terminated due to Mr. Du Bois essentially not liking what he heard in terms of what potential defenses and such he may have had. Another visit was then scheduled for yesterday that Mr. Du Bois is referencing. He and I spoke on the phone last week. The sole purpose of that visit was to discuss the note from last week and whether or not I would stay on as counsel for him. And during our phone call last week, he and I agreed, or I agreed at his request, to stay on. And finally, the last point, Judge, in terms of what we did or didn't do, as he can at least attest to this, he's got copies of his police reports. This is a preliminary examination. I spoke with him. The anticipated outcome of the preliminary examination and the anticipated motions we'd be seeking to file in court. The bottom line is this, Judge. This is an individual who knows the laws and knows his rights after he allegedly committed crimes. And at this point in time, it's, of course, his defense attorney's fault for him not adequately being represented. I was ready to conduct this preliminary examination. I've explained to him the motions that I anticipated filing based on my assessment of the case that would have led to a bind over, given the evidence in this case. He doesn't like what I had to say. I respect his wishes. I wish him nothing but the best. But in terms of the representation, and it's not just me. I have people that are very helpful, that work very hard in our firm, who try to do the things that we do. And a lot of what we do is service communities like Wexford, communities like Missaukee, communities like Sheboygan, places in northern Michigan as well as southern Michigan, where frankly there are not many standard 7 qualified attorneys to handle capital life felonies. My firm does an abundant amount of appointed cases by choice, not by need. And I wish Mr. Du Bois all the best with whoever other public defender or conflict attorney on the roster accepts his case. Thank you for allowing me to put that on the record.
Thank you. Now, Mr. Du Bois, you raised another issue, and that is.
And there it is, the defendant's last stand, accusing the judge of bias. The judge defends himself, clarifying the past ties but swearing impartiality. It's a raw, uncomfortable ending, one that leaves everyone wondering, is justice just about rules or relationships?
The friendship between Ms. Carey and myself. And yes, well, Ms. Carey and I had worked together for a number of years. She was also my chief assistant prosecutor while I was the prosecutor. And yes, we did have a friendly relationship. But I will state, since becoming judge, I don't want to say that friendship has ended, but as far as Ms. Carey and I doing anything together, that has not happened at all since I was judge. The most time we spent together was a couple of weeks ago at a conference with 4 other persons, including Mr. Champion, the chief public defender, and the community corrections director. So as far as your allegations that I can't be impartial because of a friendship that I have with the prosecutor, I don't find that persuasive. I've ruled against Ms. Carey in a number of cases as the judge, and I've ruled in favor as the judge. I've also ruled in favor against all the other prosecutors. We're in a small community, and unfortunately, that's how small communities work. But I have the ability to separate myself from any friendship that I have with somebody to make sure that justice is carried out. And if you aren't feeling that that's being done, I apologize for that. But that's simply how it is. But you can certainly raise these issues with your next attorney once they get appointed. And if you feel and that attorney feels there's a need to go ahead and file a motion to recuse myself, I'll certainly hear that motion again.
I have one now. I've written it myself. I tried to follow.
But Mr. Du Bois, you requested the appointment of an attorney, so the court can't hear that motion.
Well, but I asked him to do that before this, and do
Okay,
you see the
but so-
problem that we keep running into?
But again, that's water under the bridge. I'm just telling you, moving forward, you can discuss that
Okay.
issue with your next appointed attorney. All right?
Okay. Yes, sir.
Okay, we are adjourned.